Ladies and gentlemen, gentlemen and ladies, ladies and gents, just a little brief bit of information here at the beginning. I will be moving over to the SATCOMM channel, and I'll be under the name Regent. As you can see in the title of this video, SATCOMM Regent, I will be part of the video team for that organization, and we'll be placing videos up. And no, I won't be having the antics that I have here, but it will be more so explaining the programs at SATCOMM, explaining the upcoming events for SATCOMM, explaining exactly what we're doing. What we have right here is this program is called Yandex, and Yandex is a web browser. Now this is supposed to be moving, but my internet speed is so slow right now because of where I is, so that's the problem. So what I'm going to do is I'm going to show you how Yandex works. This is one background, this is two background. Okay, see the movement? This is three background. I like this one. Okay, this one is actually pretty nice. Okay, then you got this one, then you got this one. I don't really too much. This is not my scenery, y'all. I'm sorry, I'm just not into it. I apologize. Then you got this one. See, traffic, Moscow. Okay, stranger in Moscow. And oh, that's it. That's the final one. Okay, so let's dilly back. I think I want to use, yeah, let's try this one. Now it's going to take a year to download, so we're going to leave that alone. I'll download it next time I'm at a place where I have faster speed. Now, what I'm doing right now is I'm looking up the right to contract clause. The music playing in the background, ladies and gentlemen, is all instrumental. There may be some words here and there, but those words are non-consequential. All right, so that you guys know, got a little story to tell you. But the first thing we're going to do is enlarge the screen so that you can understand what's the contract clause. Now, most of you have heard of the contract clause. I refer to it as the right to contract clause. Whenever you hear me speak of it, you'll hear me use that phrase, the right to contract. Everyone has the right to enter into a contract. That's why none of you can cry when you sign a contract, when you agree to something and somebody says you owe me and you better pay. The contract clause basically says this. The contract law appears in the United States Constitution, Article 1, Section 10, Clause 1. The clause prohibits a state from passing any law that impairs the obligation of contracts or makes, don't worry about this, or makes anything but gold and silver tender of payment. What does making anything gold or silver tender of payment have to do with contract clause? See, this is what happens when you go to Wikipedia. The people sit up here and they put in that junk that have nothing to do with the subject matter. Sorry, I apologize, ladies and gentlemen. That's why I don't like Wikipedia, because they let just anybody comment on that particular site, and that is irritating. So we're gonna go here. Let me see. This is called Donkey something. Donkey Reel. Hey, I didn't name it. Okay. So we're going to the right to contract clause. The reason why this is so important is because each one of you must understand that a binding contract is a binding contract is a binding contract. Sorry, I've been sitting up here making videos and I didn't have the computer plugged in, and so I was at 18%. So give me 1 second, ladies and gentlemen. Had to go check on something. So now that I'm back, we can continue with our donkey reel. Ladies and gentlemen, the right to contract clause is basically simple. Let's see if this article stays on point. Article 1 of the United States Constitution, within its 10 sections, establishes the collective rights of all legislative bodies of the United States, and such as Congress, House of Representatives, and the Senate, as well as the individual state governments. Specifically, within Section 10, it is written that a state is not allowed to pass any law that impairs the obligation of contracts. Now, what do you mean that impairs the obligation of contract? Well, if you get into a contract with somebody, the state cannot make a law which says that you are not bound by the obligation of contract. Now, remember when they passed the Gold Repeal Act, the United States did not honor all of their contracts because they created a law that impaired the obligation of contracts. That's why so many people were going into court trying to sue. Okay? All right. For an example, although most states are permitted to establish their own taxes within their borders, they are not permitted to regulate interstate taxes. Why? Because that's Congress's job. This delicate balance allows them certain individual freedom. However, the contract clause disallows any states to invalidate anything on a nationwide level, including the levying of taxes and the abolishment of contracts. As a result, contracts have been the binding framework of symbolic agreements between citizens and entities. Ladies and gentlemen, it's all contract. You all really need to understand that. It's the contract with America. It's all contract. From day one, it's always been contract. So we're going to turn Curtis Mayfield down just a little bit so we can explain. Ladies and gentlemen, we're going to tell you guys a little story about a man named Brady who was busy with 3 girls of his own. There were 8 of them, and they were all together, yet they were all alone. I'm sorry. So that you all can understand what's going on, there were these gentlemen, and we might as well do it this way, because if we do it the other way, you won't get it as well. So we're going to go here. We are here on our document section. Let's go down, and we're going to go to private arbitration laws. I want y'all to stay with me because we're going to walk you through this. What happened is these individuals did something called a conditional acceptance agreement. Okay, so I'm pointing it out to you. That's the first step. They did a conditional acceptance agreement. They wrote this out. Now, we put one up there for you. This is the one we put up for you. They did their own that's up here as well, and that's in the bigger one. That's in the heavy one. Where's the one megabytes? Yeah, see, that's theirs is in the megabyte one. Okay. Yeah, that's stipulation agreement. That's not the one, even though that's 2.1 megabytes. The 1.5 megabytes is the one that includes their conditional acceptance. Okay, so they did their conditional acceptance. We put one up here for you guys, the people who have mortgages. Okay, we did one for you. And all you have to do is understand what they did is they posed questions that were similar to the questions that I asked in this document here, that a party does not have the right to protect themselves when filling out an application for a fee waiver that is illegal in the first instance. And then I speak about the voluntary subscription. So they asked questions where they already knew the answer and they could prove the answer, and that if the courts or whoever the party is were to answer the question, it would then defeat their original claim. Such as if a mortgage company is coming at you for your house saying that you owe money, then you ask them a question regarding that money, about the fact that they did not tell you about the origination of the loan, where the funds came from, that they were issuing you book entry credit, and that there was nothing in the contract prohibiting you from issuing book entry credit in the form of a payment. Okay, we put together a document for you. So that's what they did. They put together a document. But here's the unique thing about their document. Their document said, hey, how you guys doing? We're going to let you know that if you don't answer each one of these questions with specificity, then you're going to be in default of our agreement. This is an agreement. Oh, it's self-executing, binding, and it's also irrevocable. Oh, and by the way, you have 10 days to respond. Now, I had one person say, well, the rule is you're supposed to give them, excuse me, they don't make the rules as to how many days a person gets to respond. But if you read the document, it specifically says if you need an additional 10 days, you have to communicate with us and ask us in writing prior to the expiration of the original 10 days. Okay? Anyway, you know government, they ain't going to respond. But you let them know if you don't respond, that means that you are agreeing to all the terms within the framework of this agreement. Okay? And they don't respond. I have 38 different entities that have not responded. I have a couple that responded, but they didn't really respond. They just sent back a letter. I even had one court, the Second Court of Appeals with the Defrauded Homeowners of America. Please, they sent back the whole thing. So I'm going to thank them for agreeing to the contract. They sent back the whole thing, which showed their agreement and their approval. Now, wait a minute. Hold on. How you going to make them agree to your contract? Not making them agree to the contract. We gave them a choice that they needed to respond to each one of the adverbials. And if there were any questions or blah, 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 we explained what the issues were. But that they had to respond. Well, how can you make somebody respond? Oh, well, simple as this. Because we were now letting them know that there was a legal issue. That this is a legal and binding contract. Now, if they don't want to be a party to the contract, all they have to do is just respond, because these are agencies that are required to know this information. They're public servants. They're required to answer these questions. See, we're not just asking them any old questions. We're asking them the right questions. Anyway, shall I continue? Yeah. Okay. The next thing we did is we sent them a notice of default, opportunity to cure. Just a simple document. You're in default. You had 10 days to respond. You did not respond in terms and agreement with the contract. You have 10 days to respond. Not 10 days. You have 3 days to respond. 3 calendar days. Remember, if you give them days, it's always calendar, not business. You cannot just say days. You have to state whether it's calendar or business days. So it's always calendar days. You have 3 calendar days to respond as to your proof that you did not receive service of the original contract, whereby then you will have an additional 8 days to respond to that contract. They won't respond within the 3 days. Why? Because this is their routine. Then you send them your notice of intent. Now, technically, your notice of intent is already included in the original contract. Okay? So now what you do, now here's the thing, guys. I want you to understand. This is the irrevocable power of attorney. They do a self-executing irrevocable power of attorney where they take control. Now, I would show you guys some. Give me 1 second. Okay. Ladies and gentlemen, this is a self-executing irrevocable power of attorney coupled with interest. See, when they did not respond to the contract, what they did is they agreed to the contract. So in accordance with the express terms of the default provision set forth in the notice attached via reference to the special irrevocable special power of attorney coupled with interest instrument having been communicated to our offices via courier service, which shall include the United States Postal Service, a private corporation commissioned with the passage of the mails on or about October 14th by virtue of said offices, does hereby authorize Robert Dean, representing EON, Redress Right, and the EON channel, etc., all hereto on behalf of Google Incorporated, etc., all. Yeah, this is me saying, Google, thank you for giving me power and control over, that's an alias I use, Robert Dean. Anyway, ladies and gentlemen, Google has now made me its authorized agent, respecting this contract, to handle and deal with all matters. There is a document number and then there's a contract number. Each one of the documents has a document number and a contract number, just to let you guys know. This irrevocable executable contract was notarized, okay? And it becomes a binding agreement. Now, we're going to go on, we're going to finish. We're going to go on, we're going to finish. Get out of here, don't need you no more. Okay, ladies and gentlemen, the reason why this process works, because there are some people out there who are saying, well, it didn't work. The guy's still in jail. No, the guy is still in jail because he started the process when he was in jail. And ladies and gentlemen, let me see if I can pull that up. hold on. I gotta start this over, because what's gonna happen is, yeah, it's gonna make me save it. So I gotta call it arbitration again. No, let's leave it there. I'll put an A in it because I already have one called arbitration. And see, this one is arbitration award. So yeah, and so I already have one called arbitration and by itself. And so I'll put an A for arbitration. So we'll do it that way. What I have to do is I have to close it and then I have to open it again. It has a little glitch. Now I'm gonna make this quick because we're trying to explain to you guys what happened. The gentleman, his name is Bradley Christopher Stark. Okay, he's the one who invented this process, and I want to make sure we give that young man his credit because he figured it out. And he didn't have all of the steps, but I have since been in touch with Mr. Stark, and I've explained to him where he, not that where he went wrong, but where he can hammer things into the head. Okay. On the 22nd of May, 2015, both you and the United States entered into a binding stipulating and settlement agreement with us. Several addendums to the agreement have been entered into and are binding on the government as well. Pursuant to Article 5 of the agreement, and as a condition precedent to the resolution of disputes, we have, under the terms of the agreement by arbitration, we are required to attempt in good faith negotiations with you and your agents. Okay, what I need to show you guys is something whereby they can prove what they just stated. So that's the stipulation agreement. It's on the site, so you guys can go there and pull it down and figure out and find out how they did everything. Look at the dates so that you can get a step-by-step. Okay? I'm not looking for that. I want the, you know what? I didn't open the right one. I need the law so I can show you guys the law. And so I didn't open up the law. I just opened up their documents. So, oh, by the way, we called the, I can't tell it to you this way. I have to tell it to you a different way. Okay, but what I want you to see is this at the bottom. Hold on, right there. Okay, this is the case where the information was filed in 2014. But you say it says 2015 on the other paperwork. No, ladies and gentlemen, this is a different document that was filed on that date. It's attached. So hold on. Let me TikTok open public law. That's what I want. I mean, private law. Ladies and gentlemen, people have said, well, I can't find that private law and look all over for it. We put it on the site so that you'll have access to it. We called, we've asked them to search for it and look for it. They say this law does not exist. Told them, we're not asking you for the existence of the law. We're asking you for a copy of the documentation, a copy of the record. This is the government printing office. This is their GPO. Ladies and gentlemen, nobody made this up. This is the date that all of this took place on. Even calling the Library of Congress and these idiots trying to tell me that Congress doesn't meet on Saturdays. And then a month ago, this Saturday, Congress met to nominate some idiot for justice of the Supreme Court. Now, I don't care about what the man is alleged, accused of. That don't matter to me. I just don't like the process of them nominating Supreme Court justices, because they're putting people in whom they like, okay, whom they say is this and whom they say is that, and we know it's all political favors. Look, for the justice release of Bradley Christopher Stark. Okay, we don't care that the law did not pass, ladies and gentlemen, because it did pass. It did pass. This is the enactment. It did pass, be it enacted by the Senate and House of Representatives. So it did pass. The only problem is they put a stipulation in it that it would not carry until 60 days after its enactment. Hold on, let me see. I think that's in here. Hold on. Y'all let me get to the bottom of this. You gonna get to the bottom of it? I'm gonna get to the bottom of it. Where's that 60-day things? See, look, this is what it tells you. It's returned by the President of the United States with his objection to the Senate, in which it originated, and passed by the Senate on recommendation of the same. It was resolved that the bill pass 2/3 of the Senate present having voted in the affirmative. Okay, then you're going to see it passed 2/3 of the House of Representatives, okay, agreeing to pass the bill. But, ladies and gentlemen, they don't want you all to find this bill. So I need your help. I need your help to call the GPO, because I got an email back from the GPO. Y'all hold on one second. Hold on. Okay, ladies and gentlemen, this is the thank you for contacting us, GPO, Government Publishing Office, and thank you for contacting the U.S. Government Publishing Office. I have contacted the Government Info Office and got this response. This is not a valid private law. Hold on. It does not exist. However, if you could send me your source, I will try to pursue. Please contact us again if you need further assistance. So we sent them a copy of the law. They told us that, pay attention, they said this was fraudulent and they were referring it to their general counsel. Well, you know me. You referred it to your general counsel. Okay, now pay attention, you guys, for congressional record, daily complication of presidential documents, congressional record, daily computation of presidential documents, presidential signature message, because the president eventually signed it. See, Senate and House overrode veto, amended and reintroduced to the Senate, considered and passed by the Senate, considered and passed by the House. But here, you guys need to understand, these guys came back after the president passed it, and the attorney convinced the guys that if they did another amendment to help out some senator in her district, that it would help them get the law finally approved to where it moves into position for allowing them to have access to their funds. They didn't know that once it passed the House and the Senate and the president had their signature, all they had to do was wait. It may have taken a year, but all they had to do was wait. And the attorney convinced them to amend it. That's what got them to have it amended, and then it got vetoed. It was a game. This was a political game that they played, because these guys didn't know that once a bill has been passed, if you do any amendments to it, it allows it to be voted on again as if it hadn't been passed. And that's what happened to this bill. But let me show you. I'm just a bill. Yes, I'm only a bill. All you got to do is pay attention to the stupid cartoon. Okay, because I did. That's how I know about it. Too many years listening to the same cartoon. That's why I'm just a bill. Yes, I'm only a bill. And I got as far as Capitol Hill. I am 50 years old, people. And I remember that stupid cartoon. Okay? I paid attention to it. Now, I want y'all to understand something so y'all get it, because I know some of y'all didn't get it and I tried to explain it to you, but some of y'all just, bless your little hearts. Anyway, findings of Congress. Ladies and gentlemen, this is before the act passed. This is the same language in the bill. The Congress finds the following. We don't need the bill to pass to have this, to use this language, that the United States, by and through the Attorney General, entered into an agreement with the parties. The agreement is a valid and binding settlement agreement between the parties in the United States, and it operates in the nature of a release dismissal agreement. Now, hold on, so that y'all get it. Congress is saying that the agreement is binding. Now, when they talk about settlement agreement, it's because the guys, after they got their arbitration, the agreement contains an alternative dispute resolution. Arbitration is an alternative dispute resolution clause that provided for arbitration as the exclusive remedy for relief to the parties in the United States. They couldn't go to court to get this issue resolved. It could only be handled through arbitration. The arbitration was awarded to these guys. Why? Because the other party had agreed, and they showed and provided proof that they had been served and had an opportunity to respond. Yes, they bound the Attorney General of the United States to an agreement because of their failure and refusal to respond, because the failure and refusal to respond was a part of the contract as tacit acquiescence that they were agreeing to all the terms of the agreement. The United States consented to the arbitration. How? Because it was part of the agreement. And the award made by the arbitrator for equitable relief of the parties and the United States are binding. Whatever award the arbitrator made was binding on both parties. Well, guess what? The contract includes an arbitration clause, but I can't tell you how I've amended mine. Anyway, Congress hereby expressly waives any defenses to the equitable relief award to the parties, beneficiaries, corporate beneficiaries, by the arbitrator. Do you know they tried to go after the arbitrator, saying that she was attempting to defraud the United States prior to the Congress coming to this conclusion? It was because of Congress coming to these findings that they dismissed the case and sealed it. You won't find the case with the arbitrator. Okay, they sealed that one. And they would have sealed these guys' cases too, but they didn't know that they kept a copy of the law. You see, they removed the law from the public record so that you can't get access to it, but we have a copy of the actual law. So they say they want to send it to their general counsel. I told them, I said, wait a minute, your general counsel is not a public servant. He's a private entity that you all hired separately outside the scope of your official duties. So no, you don't get to have me talk to somebody who doesn't have an official capacity with your organization. Whenever you're speaking to somebody's legal counsel, do you understand? And especially if they're government, they're not a government employee. The legal counsel is a subcontractor. So I told him, no, I don't care about your subcontractor. And who cares if you send it to the legal counsel? You're accusing somebody of fraud. I said, do you know there are 5 elements to fraud? So if this is fraud, now you need to prove your allegation because you just made an accusation against someone that is a slanderous and a libel accusation. I haven't heard back from them since. So I'll be giving them a call back on Monday. Ladies and gentlemen, I just need you to call the GPO and ask them about this law. What law? I don't even know what law you're talking about. I ain't even seen the law. Well, this is the law right here. Private law 11431. They will tell you that they looked it up and there was nothing done in that, blah, blah, blah. No. I have a copy of it. Well, can you send us a copy? We've already been sending you copies, myself and several others, and you guys are not responding. Okay? So we need to see the actual record because we are not caring about the law, people. What we are caring about is the record of this, the findings of Congress. Because once we get this, look, if they say that our contracts are not binding, our contracts are garbage, our contracts are, well, they didn't say it was gibberish, but if they say it's gibberish, ladies and gentlemen, guess what? The moment they say our contracts are invalid, guess what we get to say? Hold on, so that y'all can hear it, because I want y'all to see it. We get to say that their contracts are invalid. We get to say that they're impeding the obligation of contract, which is illegal. We get to now challenge every single court case every single time they open their mouths. You see, if they don't have to respond to our contracts, pay attention. If they don't have to respond to our contracts, we don't have to respond to theirs. So if they say that our contracts are not binding, even though they received them and did not respond, and the contract said that if they did that, they would be knowingly entering into the contract. If they say that that does not constitute an agreement, then we say, okay, fine. So the next time you or any of your agents send out notices or summonses or subpoenas, individuals don't have to respond to that. No, that's not the same thing. Oh, it is the exact same thing. This is notice, agent, principle, procedure, fundamental, policy, and guess what, homeboy? You sitting up there sending out all this junk to people, telling them that they got to respond to you? Okay, well, guess what? We get to do the same. It's called equal protection of law. And there is no law prohibiting us from doing it. Go ahead, open your mouth and tell us what that law is that says we can't do exactly what you just did. That we have to be government in order to send a contract to somebody, to send a notice to someone. Go ahead, show me that law. So if mine are not binding, then yours are not binding. And I will use this case as a precedent. President. I'm president of the United. Anyway, I'll use this case as a precedent to make sure that everybody and their grandfather know that it has just been decided by this official court of record that notices do not constitute notices, and that individuals do not have to respond to notices. They can simply ignore them. Ladies and gentlemen, do you understand? That means that all the junk they've been doing is not allowable, not permitted. Let me show y'all something so y'all can, let me tell you something. The reason why Congress found that the agreement was binding on the Attorney General of the United States and the other parties is because if they found it wasn't, then they could then take this and say, oh no, your agreement is not binding, because Congress says we don't have to respond to your junk when you send it out. Do you understand? Congress could not do that. Oh, I'm sorry. Ladies and gentlemen, let me show you why Congress had to get involved. Because of this language right here. Now, the courts have been trying to skirt around it because, you know, they've been trying to put their own little spin in it. I'm sorry, I can't do that. I apologize. I got to do it this way. It says that no state shall pass a law. Well, the First Amendment of the Constitution says Congress shall make no law. That's how we know that only Congress can make law in the United States. Okay, the courts are saying in this instance that, well, Congress was indicating that when they said no state may pass a law, that it was not referring to the courts. Of course it wasn't, because the courts don't have the ability to pass law or judicial decisions. No, judicial decisions, no. Oh, by the way, this contract, when you contract with the United States, it's considered a treaty. So let's see if we can pull up the actual contract clause, because this is just an article talking about it. I want the actual clause itself that actually says the word. Nope, it's not there. So let's see if we can go back. Tick tock, tick tock, tick tock. Oh, that's right. I didn't do it the right way. Okay. Let's go RIGHT. All right. I want the actual Constitution clause. See, freedom of contract. It's the right to contract. See, there it is. You see that right there? That's the way I've learned it. Okay? American courts began to assert that a right to contract free from unreasonable government regulations is protected by the Due Process Clause of the Fifth Amendment, not no stupid 14th Amendment. Anyway, ladies and gentlemen, the reason why I pointed out the obligation of contract, you won't get it because, how do I put this? You won't get it because you don't see it. And that's okay, because I don't expect everybody to see it. This is the exact same article that I use for my definitions. Ladies and gentlemen, pay attention. No state shall enter into any treaty, alliance, or confederation. Okay? Don't worry about the rest of this. Don't worry about the rest of this. Okay? Or pass any, don't worry about this, law impairing the obligation of contract. Don't worry about that. So, because this speaks of treaty, because a treaty is a contract, only Congress, because of this right here, passing a law, see, pass any law impairing the obligation of contract. That means only Congress can determine whether a contract is binding concerning the United States and another party. So when these gentlemen went to Congress and they said, hey, Congress, hey, how y'all doing? We got our little private little thing right here. And Congress had no choice. Why do you think Congress brought it back before the Senate? I guarantee you, if you can read their notes and check their findings, you will find the same thing. Now, some people are going to sit up here and do the process. They're going to do their own little thing, because you know how people, we got our own thing. Anyway, ladies and gentlemen, and they're going to mess things up for everybody else, and that's okay, because you're not going to mess things up for us. We put the information up here so that you can put the pieces together and do the exact same. But we need help getting a copy of this. Oh, by the way, I'm looking for an arbitrator. I'm looking for an arbitrator for which we can utilize. Now, there won't be a personal relationship. I don't know the arbitrator. I'm looking for one. And the arbitrator will not be working for SATCOM, won't be doing anything for SATCOM, won't be doing anything for me. I'm just looking for an arbitrator. If you're an arbitrator and you want to sit up there and have us generate business your way, by all means, give us a contact. You can go to now, ladies and gentlemen, let's do this. Nope, not there. I'm on the right page and I'm clicking on the wrong thing. Let's do this. Tone Loc. Wow, dang. Well, that's how he starts the song. Let's do it. Okay. It says contact us. Okay. It says contact us. And when you click on the contact us form is only one click away. Come on, TikTok. You notice how it spells 1844 SATCOM? Hey! No wonder. I didn't know it wasn't working. I know it's not working now. I will correct that. I will correct that tonight because that's supposed to be working. All right, we'll take care of that tonight. All right, ladies and gentlemen, gentlemen and ladies and gents, what you'll do is you will, if you are a notary, and it will be corrected by the time this video is up. I didn't know it wasn't working. I see it's not working. So that means that I can't go to sleep. I got to fix it now. But ladies and gentlemen, the process does work. You are just going to have to take your time, understand the process, understand the paperwork, and then move forward. Some of you are going to try to put exorbitant amounts of dollar figures there. That's not the way you're going to make anything work. You will not be taken seriously. You really will not be taken seriously. You cannot reason your way. You have to be reasonable because the law requires that you be reasonable. Okay? So I will have to say adieu. I'm glad that I was able to put forth some information. We will chit-chat, but from this point on, I'll be explaining SATCOM's programs on SATCOM. Have a good day. Have a good night. Have a good life. Have a good bye.